jingle bell, jingle bells swing and jingle bells ring, snowing and blowing a bushel of fun. Now the jingle hop has begun. Giddy up, jingle horse, pick up those feet. Jingle bell round the clock. Mix and mingle in a jingling beat. That's the jingle bell rock. What a bright time, it's the right time to rock the night away. Jingle bell time is a swell time to go gliding in a one-horse sleigh. Giddy up, jingle horse, pick up those feet. Jingle bell round the clock. Mix and mingle in a jingling beat. That's the jingle bell rock.
Stable swing, are you listening?
The snowman was a jolly happy soul, with a corncob pipe and a button nose and two eyes made out of gold. Frosty the snowman is a fairy tale, they say. He was made of snow, but the children know how he came to life one day. There must have been some magic in that old silk hat they found. Oh, when they placed it on his head, he began to dance around. Rudolph the red-nosed reindeer had a very shiny nose, and if you ever saw it, you would even say it glows. All of the other reindeers used to laugh and call him names. They never let poor Rudolph join in any reindeer games. Then one foggy Christmas Eve, Santa came to say, Rudolph, with your nose so bright, won't you got my sleigh tonight? Then how the reindeers loved him as they shouted out with glee, Rudolph the red-nosed reindeer, you go down in history.
Those sleigh bells jingling, ting, ting-a-ling-a-ling too. Come on, it's lovely weather for a sleigh ride together with you. Outside the snow is falling and friends are calling you. Come on, it's lovely weather for a sleigh ride together with you. Giddy up, giddy up, giddy up, let's go. Let's look at the show. We're riding in a wonderland of snow. Giddy up, giddy up, giddy up, it's grand. Just holding your hand. We're gliding along with the song of the wintry fairyland.
Consolidated Civil Proceedings Rules 2016-79. Part 11 General Rules about Applications. For Court Orders. Contents of this part. Scope of this part. Rule 11.1 Applicants and Respondents. Rule 11.2 Where to make an application. Rule 11.3 Application to be in writing. Rule 11.4 Notice of application and evidence in support. Rule 11.5 Time when an application is made. Rule 11.6 What an application must include. Rule 11.7 Evidence in support of an application. Rule 11.8 Contents of Notice of Application. Rule 11.9 Service of Notice of Application. Rule 11.10 Powers of Court in relation to the conduct of an Application Rule 11.11 Consequence of not asking for order in Application Rule 11.12 Application which may be dealt with without hearing. Rule 11.13 Service of application where order made on application made without notice. Rule 11.14 Application to set aside or vary order made on application made without notice. Rule 11.15 Power of court to proceed in absence of a party. Rule 11.16 Application to set aside order made in the absence of a party. Rule 11.17 Scope of this part 11.1 This part deals with applications for court orders made before, during, or after the course of proceedings. Applicants and respondents 11.2 Applicant means a person who seeks a court order by making an application, and respondent means a. the person against whom the order is sought, and b. such other person as the court may direct is to be served with the application. 2016 Supreme Court of Judicature of Trinidad and Tobago. 80 Consolidated Civil Proceedings Rules 2016. Where to make an application 11.3 1. The general rule is that an application should be made to the court office where the claim was issued. 2. If the claim has been transferred to another court office, the application should be made to that court office. 3. If the application is made before a claim has been issued, it must be made to the court office where it is likely that the claim to which the application relates will be made. Application to be in writing 11.4 1. The general rule is that an application must be in writing. 2. An application may be made orally if a. this is permitted by a rule or practice direction, or b. the court dispenses with the requirement for the application to be made in writing. Notice of application and evidence in support 11.5 1. The general rule is that the applicant must give notice of the application to each respondent. 2. An applicant may make an application without giving notice if this is permitted by a. a rule, or b. a practice direction. 3. Evidence in support of an application is not needed unless it is required by a. a rule, b. a practice direction, or c. a court order. 4. Notice of the application must be included in the form used to make the application. Time when application is made 11.6 Where an application must be made within a specified period, it is so made if it is received by the court office or made orally to the court within that period. What an application must include 11.7 1. An application must state a. what order the applicant is seeking, and b. briefly, why the applicant is seeking the order. Supreme Court of Judicature of Trinidad and Tobago 2016. Consolidated Civil Proceedings Rules 2016-81. 2. The applicant must include with, or attach to the application, a draft of the order he is seeking. 3. Either the applicant or his attorney-at-law must certify on the application that he believes any facts stated in the application are true. Evidence in support of application 11.8 Where evidence in support of an application is required, it must be contained in an affidavit unless a. a rule, b. a practice direction, or c. a court order otherwise provides. Part 31 deals with affidavit evidence. Contents of notice of application 11.9 1. If there is to be a hearing, the notice must state the date, time, and place of the hearing. 2. If there is not to be a hearing but notice of the application is required, the notice must state how the court will deal with the application. Rule 11.13 sets out the circumstances in which there may not be a hearing. Service of notice of application 11.10 1. The general rule is that a notice of an application must be served a. as soon as practicable after the day on which it is issued, and b. at least 7 days before the court is to deal with the application. 2. However, the period in paragraph 1b shall not apply where any rule specifies some other period for service. 3. If a. notice of an application has been given, but b. the period of notice is shorter than the period required, the court may nevertheless direct that, in all the circumstances of the case, sufficient notice has been given, and may accordingly deal with the application. 4. The notice must be accompanied by a. any evidence in support, and B. A copy of any draft order which the applicant has attached to his application. 5. The notice must be served in accordance with Part 6. 2016 Supreme Court of Judicature of Trinidad and Tobago. 82 Consolidated Civil Proceedings Rules 2016. Powers of Court in relation to the conduct of an application 11.11. 1. The court may a. Issue a witness summons requiring a party or other person to attend the court on the hearing of the application. B. Require a party to produce documents or things at such a hearing. And c. Question any party or witness at such a hearing. 2. The court may examine a party or witness a. Orally, or b. By putting written questions to him and asking him to give written answers to the questions. 3. Any party may then cross-examine the witness. 4. The court may exercise any power which it might exercise at a case management conference. Consequences of not asking for order. In application 11.12, an applicant may not ask for an order for which he is not asked in his application unless the court permits him to do so. Applications which may be dealt with without hearing. 11.13 The court may deal with an application without a hearing if a. The parties agree that the court should dispose of its application without a hearing. B. The court considers that the application can be dealt with over the telephone or by other means of communication. C. The parties have agreed to the terms of an order I, which do not come within Rule 27.9, 1, and 2. The application, or a copy of the application, is signed by all parties to the application or their attorneys at law. Or D. The court does not consider that a hearing would be appropriate. Rule 43.7 deals with consent orders. Service of application where order made on application made without notice. 11.14. 1. After the court has disposed of an application made without notice, in addition to serving a copy of any order made, a copy of the application and any evidence in support must be served on all parties. 2. When such an application is made, the applicant must file sufficient copies of the application and evidence in support for service on all other parties who may be affected by the order. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-83. 3. Where an urgent application is made without notice and the applicant undertakes to file evidence after the hearing, he must serve copies of the application and evidence on all other parties affected by the order. Application to set aside or vary order made on application made without notice. 11.15. 1. A respondent to whom notice of an application was not given may apply to the court for any order made on the application to be set aside or varied, and for the application to be dealt with again. 2. A respondent must make such an application not more than 7 days after the date on which the order was served on him. 3. An order made on an application of which notice was not given must contain a statement telling the respondent of his right to make an application under this rule. Power of the court to proceed in the absence of a party. 11.16. Where the applicant or any person on whom the notice of application has been served fails to attend the hearing of the application, the court may proceed in his absence. Application to set aside order made in the absence of a party. 11.17. 1. A party who was not present when an order was made may apply to set aside that order. 2. The application must be made within 7 days after the date on which the order was served on the applicant. 3. The application to set aside the order must be supported by evidence showing a. A good reason for failing to attend the hearing, and b. That it is likely that had the applicant attended, some other order might have been made. 2016 Supreme Court of Judicature of Trinidad and Tobago. 84 Consolidated Civil Proceedings Rules 2016. Cases. 2014 Privy Council/Court of Appeal. Beulah G. Pompey v. Stephen Rollinson Civ. App No. S062 of 2014, April 28, 2014. Appeal allowed CV 2013-03696, March 10, 2014. Rule 11.17, setting aside ex parte order, consideration of all factors, also under Part 40. High Court. Ricardo Welch v. the Attorney General of Trinidad and Tobago and others, CV 2013-04279, March 19, 2014, Rule 11.17, setting aside ex parte order, consideration of all factors, also under Parts 2 and 67. 2012 High Court. Professor Courtney Bartholomew and another v. Dr. Steve Smith, CV 2010-02370, October 30, 2012, Rule 11.4, Oral Application for Judgment, Fit and Proper Case TO dispense with requirement for an application in writing. David Walcott v. Keith Hercules, Chief Immigration Officer and others, CV 2011-01859, February 24, 2012, Oral Application, striking out, litigant in person. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-85. 2011 Privy Council/Court of Appeal. Allen Dick and Company Limited v. Fast Freight Forwarders Limited and another Civ App No. P214 of 2010, May 23, 2011, Appeal dismissed Rule 11.14, Rule 11.15, setting aside timeliness of application, failure to comply with CPR, effective failure, also under Parts 19 and 64. 2007 High Court. Global Television Production Company Limited v. Mohan Jaikaran, CV 2007-001168, April 23, 2007, Rule 11.15, ex parte order, Respondent's right to apply not stated, application to discharge, defect in application, discretion. 2006 High Court. Christine Miller and another v. Classic Developers Limited, CV 2006-01510, November 28, 2006, Rule 11.4, Oral Application for Judgment on Admission made at CMC, requirement for writing dispensed. 2016 Supreme Court of Judicature of Trinidad and Tobago. 86 Consolidated Civil Proceedings Rules, 2016. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-87. Part 12 Default Judgments. Contents of this part. Scope of this part. Rule 12.1 Claims in which default judgment may not be obtained. Rule 12.2 Conditions to be satisfied. Judgment for failure to enter appearance. Rule 12.3 Conditions to be satisfied. Judgment for failure to defend. Rule 12.4 Procedural requirements. Rule 12.5 Claim for specified sum of money. Rule 12.6 Nature of default judgment. Rule 12.7 Interest. Rule 12.8 Costs. Rule 12.9 Directions to be given where further decision of court is needed. Rule 12.10 Defendant's rights following default judgment. Rule 12.11 Claim against more than one defendant. Rule 12.12 Scope of this part. 12.11. This part contains provisions under which a claimant may obtain judgment without a trial where a defendant, A, has failed to enter an appearance giving notice of intention to defend in accordance with Part 9, or, B, has failed to file a defense in accordance with Part 10. 2. Such a judgment is called a default judgment. Claims in which default judgment may not be obtained. 12.2. 1. A claimant may not obtain default judgment where the claim, A, is a fixed date claim, B, is an admiralty claim in rem, or, C, a claim in probate proceedings. Rule 74.22 makes special provision for default judgment in admiralty cases for personal injury arising out of a collision between two ships. 2. A claimant needs permission from the court if he wishes to obtain default judgment on any claim which is A, a claim against a state, B, a claim against a minor or patient as defined in Rule 2.3, or C, an action in tort brought by one party to a marriage against another. 2016 Supreme Court of Judicature of Trinidad and Tobago. 88 Consolidated Civil Proceedings Rules, 2016. Part 58 deals with proceedings against the state. Part 23 deals with proceedings involving a minor or patient. 3. An application for permission must be supported by evidence. Conditions to be satisfied. Judgment for failure to enter appearance. 12.3 At the request of the claimant, the court office must enter judgment for failure to enter appearance if a. The court office is satisfied that the claim form and statement of case have been served. b. The period for entering an appearance has expired. c. The defendant, I, has not entered an appearance. 2. Has not filed a defense to the claim or any part of it. 3. Where the only claim is for a specified sum of money, apart from costs and interest, has not filed an admission of liability to pay all of the money claimed together with a request for time to pay it, or 4. Has not satisfied the claim on which the claimant seeks judgment, and d. Where necessary, the claimant has permission to enter judgment. Rules 5.5, 5.9, 5.10, and 5.13 deal with how to prove service of the claim form and statement of case. Conditions to be satisfied. Judgment for failure to defend. 12.4 At the request of the claimant, the court office must enter judgment for failure to defend if a. The court office is satisfied that the claim form and statement of case have been served, or b. An appearance has been entered, and c. The period for filing a defense has expired. d. The defendant, I, has not served a defense to the claim or any part of it. 2. Where the only claim is for a specified sum of money, has not filed or served on the claimant an admission of liability to pay all of the money claimed, together with a request for time to pay it, or 3. Has not satisfied the claim on which the claimant seeks judgment, and e. Where necessary, the claimant has the permission of the court to enter judgment. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-89. Procedural requirements. 12.5 1. A claimant obtains default judgment by filing a request, Form 6. 2. The judgment takes effect from the date that all requisite documents have been filed. Claim for specified sum of money. 12.6 1. The fact that the claimant also claims costs and interest at a specified rate does not prevent a claim from being a claim for a specified sum of money. 2. Where the claimant claims a specified sum of money together with interest at an unspecified rate, he may either a. Enter judgment under this part for the sum of money claimed together with interest at the statutory rate from the date of the claim to the date of entering judgment, or b. Enter judgment for the sum of money claimed and for interest to be assessed. 3. For the purpose of this part and of Rule 14.5, a claim for a. The cost of repairs executed to a vehicle or any property in, on, or abutting a road, or b. Any other financial losses claimed as a result of damage which it is alleged to have been caused in an accident as a result of the defendant's negligence is to be treated as a claim for a specified amount of money provided that I. The amount of each item in the claim is specified, and 2. Copies of receipted bills for the amounts claimed are attached to the claim. Nature of default judgment. 12.7 1. Default judgment shall be a. On a claim for a specified amount of money, judgment for the payment of that amount at the time and rate specified in the request for judgment. b. On a claim for possession of land, judgment for possession on a date to be specified in the request. c. On a claim for an amount of money which is not specified, judgment for the payment of an amount to be decided by the court. d. On a claim for goods, either I. Judgment requiring the defendant either to deliver the goods or pay their value as assessed by the court. 2. Judgment requiring the defendant to pay the value of the goods as assessed by the court. 2016 Supreme Court of Judicature of Trinidad and Tobago. 90 Consolidated Civil Proceedings Rules 2016. 3. Where the claim form specifies the value of the goods, judgment for that amount. Or 4. If the court gives permission, a judgment requiring the defendant to deliver the goods without giving him the alternative of paying their assessed value. 2. An application for permission to enter a default judgment under paragraph D. 4. must be supported by evidence and a copy of the application, and the evidence must be served on the defendant against whom judgment has been sought even though he has failed to enter an appearance or file a defense. 3. Where a claim is partly for a specified sum and partly for an unspecified sum, the claimant may abandon the claim for the unspecified sum and enter default judgment for the specified sum. 4. Default judgment where the claim is for some other remedy shall be such judgment as the court considers the claimant to be entitled to. Interest 12.8. 1. Default judgment shall include judgment for interest for the period claimed where a. the claim includes a claim for interest, and b. the claim form or statement of case includes details of I. the amount of interest claimed, 2. the rate, and 3. the period for which it is claimed, and c. the request states the amount of interest to the date it was made. 2. If the claim includes any other claim for interest, default judgment shall include judgment for an amount of interest to be decided by the court. Costs 12.9. Default judgment gives a claimant a right to fixed costs unless the court assesses the costs. Rule 67 sets out what are fixed costs and how costs are assessed. Directions to be given where further decision of court is needed. 12.10 Where default judgment is entered and a further decision of the court is needed under Rule 12.7, 1, C, or D, or Rule 12.7, 4, or Rule 12.8, 2, the court must give directions for the resolution of any outstanding matters. Part 16 deals with the procedure for assessment of damages. LN 126 of 2011. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-91. 3. Where the claim form specifies the value of the goods, judgment for that amount, or 4. If the court gives permission, a judgment requiring the defendant to deliver the goods without giving him the alternative of paying their assessed value. 2. An application for permission to enter a default judgment under paragraph D. 4. Must be supported by evidence and a copy of the application, and the evidence must be served on the defendant against whom judgment has been sought even though he has failed to enter an appearance or file a defense. 3. Where a claim is partly for a specified sum and partly for an unspecified sum, the claimant may abandon the claim for the unspecified sum and enter default judgment for the specified sum. 4. Default judgment where the claim is for some other remedy shall be such judgment as the court considers the claimant to be entitled to. Interest 12.8. 1. Default judgment shall include judgment for interest for the period claimed where a. the claim includes a claim for interest, and b. the claim form or statement of case includes details of I. the amount of interest claimed, 2. the rate, and 3. the period for which it is claimed, and c. the request states the amount of interest to the date it was made. 2. If the claim includes any other claim for interest, default judgment shall include judgment for an amount of interest to be decided by the court. Costs 12.9 Default judgment gives a claimant a right to fixed costs unless the court assesses the costs. Rule 67 sets out what are fixed costs and how costs are assessed. Directions to be given where further decision of court is needed. 12.10 Where default judgment is entered and a further decision of the court is needed under Rule 12.7, 1, C, or D, or Rule 12.7, 4, or Rule 12.8, 2, the court must give directions for the resolution of any outstanding matters. Part 16 deals with the procedure for assessment of damages. LN 126 of 2011. Defendant's rights following default judgment. 12.11 Unless he obtains an order for the judgment to be set aside, the only matters on which a defendant against whom a default judgment has been entered may be heard are a. the assessment of damages, provided that he has indicated that he wishes to be heard, I. on the appearance form, or 2. in a notice under Rule 16.2, for b. costs, c. the time of payment of any judgment debt, and d. enforcement. Part 10.2 deals with a defendant who admits liability but wishes to be heard on the issue of quantum, and Part 13 deals with setting aside or varying default judgments. Claim against more than one defendant. 12.12. 1. A claimant may obtain default judgment on a claim for money or a claim for delivery of goods against one of two or more defendants and proceed with his claim against the other defendants. 2. Where a claimant makes a claim for money or a claim for delivery of goods against more than one defendant. B. The claimant alleges that the defendants are jointly liable. C. Default judgment is entered under Rule 12.7. 1. C. Claim for amount of money to be assessed by the court, or 12.7. 1. D. Claim for delivery of goods or for value of goods to be assessed by the court, against one or more defendants, and D. The proceedings continue against any other defendant. The court may defer until the trial determination of the amount which a defendant against whom judgment has been entered under this part is liable to pay. 3. Where a. The claimant applies for default judgment on any claim which is not a claim for money, a claim for recovery of goods, or a claim for possession. B. The claim is made against two or more defendants, and C. The claim against the defendant or defendants in default can be dealt with separately from the claim against the other defendants. The court may give default judgment against the defendant in default and the claimant may continue the proceedings against the other defendants. 2016 Supreme Court of Judicature of Trinidad and Tobago. 92 Consolidated Civil Proceedings Rules 2016. 4. Where, in a claim to which paragraph 3 applies, the court office may not enter judgment against the defendant in default. The court must deal with any application for default judgment against that defendant at the same time as it disposes of the claim against the other defendants. 5. Where a claim for possession of land is made against more than one defendant, with or without any other claim, the claimant may not enforce any judgment for possession entered under this part against any one or more defendants without the permission of the court until judgment is given for possession against all the defendants to the claim for possession. Former rule. The current Rule 12.11 was brought about by the revocation and substitution of Rule 12.11 by Rule 7 of the Civil Proceedings Amendment Rules, 2011 Legal Notice Number 126 of 2011. As set out in the 2006 publication, Rule 12.11 read as follows: Defendant's rights following default judgment. 12.11 Unless he obtains an order for the judgment to be set aside, the only matters on which a defendant against whom a default judgment has been entered may be heard are a. Costs, b. The time of payment of any judgment debt, and c. Enforcement. Part 13 deals with setting aside or varying default judgments. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-93. Cases. 2014 Privy Council/Court of Appeal. Roland James v. the Attorney General of Trinidad and Tobago Civ. App No. P044 of 2014, December 19, 2014. Appeal dismissed. Rule 12.2. 2. Default judgment application. Extension of time to file defense. Consideration of factors, overriding objective and Rule 26.7 without threshold requirements. Also under Parts 1 and 10. Dennis Gillard v. the Attorney General of Trinidad and Tobago Civ. App No. P192 of 2013, February 11, 2014. Appeal dismissed. CV 2009-03903, July 29, 2013. Rule 12.2. 2. Permission, default of defense, delay, automatic striking out. Also under Parts 8 and 26. 2013 High Court. Reinvestments Limited v. Helga J. Rees and another CV 2012-02369, December 18, 2013, Rule 12.2, Fixed Date Claim, Default Judgment Inapplicable. 2012 Privy Council/Court of Appeal. Okpadagwa v. Dhunraj Balkaran and others, Civ. App No. S103 of 2009, June 22, 2012. Appeal allowed. Default judgment. Proceedings continued against other defendants. 2016 Supreme Court of Judicature of Trinidad and Tobago. 94 Consolidated Civil Proceedings Rules 2016. High Court. Samuel Alford and others v. Leonora Balfour and another CV 2009-03461, July 6, 2012, Rule 12.7 Application for Directions, Default of Defense, Nature of Claim, Discretion, also under Part 1. Anthony Z. James v. the Attorney General of Trinidad and Tobago CV 2011-04199, June 5, 2012, Part 12, Default Judgment Application Premature, also under Part 10. 2009 High Court. Kevin Philip v. Bernard Williams and another CV 2008-01338, July 3, 2009, Rule 12.2, Rule 12.9, Default of Defense, Permission to enter default judgment. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-95. Part 13 Setting aside or varying. Default judgment. Contents of this part. Scope of this part. Rule 13.1 Cases where the court must set aside judgment entered under Part 12. Rule 13.2 Cases where the court may set aside or vary judgment entered under Part 12. Rule 13.3 Application to vary or set aside judgment. Procedure. Rule 13.4 Court to impose condition as to filing of defense. Rule 13.5 Hearing may be treated as case management conference. Rule 13.6 Scope of this part. 13.1 The rules in this part set out the procedure for setting aside or varying a default judgment entered under Part 12, Default Judgments. Part 48 deals with variation of the terms of a judgment as to time and method of payment. Cases where the court must set aside judgment entered under Part 12. 13.2. 1. The court must set aside a judgment entered under Part 12 if judgment was wrongly entered because a. In the case of a failure to enter an appearance, any of the conditions in Rule 12.3 was not satisfied, or b. In the case of judgment for failure to defend, any of the conditions in Rule 12.4 was not satisfied. 2. The court may set aside judgment under this rule on or without an application. Cases where the court may set aside or vary judgment entered under Part 12. 13.3. 1. The court may set aside a judgment entered under Part 12 if a. The defendant has a realistic prospect of success in the claim, and b. The defendant acted as soon as reasonably practicable when he found out that judgment had been entered against him. 2. Where this rule gives the court power to set aside a judgment, the court may instead vary it. 2016 Supreme Court of Judicature of Trinidad and Tobago. 96 Consolidated Civil Proceedings Rules 2016. Application to vary or set aside judgment. Procedure. 13.4. 1. An application under Rule 13.2. Cases where the court must set aside judgment may be made by a. The defendant, b. The claimant, or c. Any other person who is directly affected by the entry of judgment. 2. An application under Rule 13.3. Cases where the court may set aside or vary judgment may be made by a. The defendant, or b. Any other person, except the claimant, who is directly affected by the entry of judgment. 3. A claimant who applies to set aside judgment under paragraph 1 may do so without giving notice. 4. An application under paragraph 1c or 2b need not be served on the defendant. 5. An application, other than an application by a claimant, must be supported by evidence. Court to impose condition as to filing of defense. 13.5. 1. If judgment is set aside under this part, the general rule is that the order must be conditional upon the defendant filing and serving a defense by a specified date. 2. The general rule shall not apply if the court is satisfied that the defendant was not served with the claim form and statement of case. Hearing may be treated as case management conference. 13.6. 1. When judgment is set aside under this part, the court must treat the hearing as a case management conference unless it is not possible to deal with the matter justly at that time. 2. If it is not possible to deal with the matter justly at that time, the court office must fix a date, time, and place for a case management conference. Part 26 deals with the powers of the court on a case management conference. Part 27 deals with the procedure for case management conferences. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-97. Cases. 2016 High Court. Climate Control Limited v. CG Construction Services Limited CV 2015-03486, March 21, 2016, Part 13, Default Judgment, Setting Aside, no Realistic Prospect of Success. 2015 High Court. Island Roofing and Hardware Solutions Limited v. May Hardware Limited CV 2014-01875, December 1, 2015, Judgment in Default of Appearance, Setting Aside, Failure to act when reasonably practicable, Realistic Prospect of Success. Roger Franco v. Paul Priscilla and others CV 2014-02934, September 15, 2015, Judgment in Default of Appearance, Setting Aside, Realistic Prospect of Success is Delay, CPR Requirements Satisfied, also under Part 6. 2014 Privy Council/Court of Appeal. Neil R. C. Prasad and another v. Rashid Ali of Ali's Poultry and Meat Supplies Civ App No P316 of 2014, December 15, 2014. Appeal allowed CV 2013-01618, December 8, 2014, Rule 13.3, Judgment in Default of Defense, Setting Aside, Requirements Not Satisfied. 2016 Supreme Court of Judicature of Trinidad and Tobago. 98 Consolidated Civil Proceedings Rules, 2016. Selwyn Riley v. Winston Cuffey Civ App No. S272 of 2014, November 17, 2014. Appeal allowed CV 2011-04837, November 7, 2014. Judgment in Default of Appearance, Setting Aside, Delay, also under Part 26. Rampersad Maharaj and another v. Motor 1 Insurance Civ App No. S213 of 2014, October 20, 2014. Appeal dismissed CV 2013-3656, September 17, 2014, Rule 13.3, Judgment in Default of Appearance, Setting Aside, Requirements Satisfied. Building Concepts and Construction Limited v. the Trinidad and Tobago Housing Development Corporation Civ App No. P166 of 2014, July 21, 2014. Appeal dismissed CV 2012-02508, July 1, 2014, Rule 13.3, Judgment in Default of Defense, Setting Aside, Requirements Satisfied. The Caribbean New Media Group Limited v. Ingrid Isaac Civ App No. S209 of 2013, April 17, 2014. Appeal allowed Rule 13.3, Default Judgment, Setting Aside, Second Limb of Test Wide Enough for Range of Circumstances. Deswart Band v. Ruben Kanhai and another Civ App Nos S285 and S286 of 2013, January 27, 2014. Appeal allowed CV 2012-02682, CV 2012-02684, December 5, 2013, Rule 13.2, Judgment in Default of Appearance, Setting Aside, Irregularity in Service. Proof of Identification, also under Part 5. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-99. High Court. First Citizens Bank Limited v. Jennifer Daniels and others CV 2013-00136, November 7, 2014, Part 13, Judgment in Default of Defense, Setting Aside, no Realistic Prospect of Success. Hamid Mohammed v. Alan Bullock and others CV 2012-01932, February 14, 2014, Rule 13.3, Judgment in Default of Appearance, setting aside, delay. Andrew Singh v. Garvin Hippolyte and another CV 2006-01543, January 16, 2014, Rule 13.2, Rule 13.3, Judgment in default of appearance, setting aside a delay, also under Part 22. 2013 Privy Council/Court of Appeal. Lyra Skinner and another v. Dynasty Holdings Limited Civ App No. P136 of 2012, December 5, 2013, appeal dismissed CV 2010-00307, June 26, 2012, Rule 13.3, Default Judgment, judgment not entered by registrar, requirements satisfied, judgment would be liable to be set aside. Anthony Ramkasoon v. Mohanlal Bhagwansingh Civ App No. S163 of 2013, July 19, 2013, Rule 13.3(1)(a), judgment in default of defense, setting aside, requirements not satisfied, appeal dismissed. 2016 Supreme Court of Judicature of Trinidad and Tobago. 100 Consolidated Civil Proceedings Rules 2016. High Court. Design Collaborative Associates Limited and another v. Urban Development Corporation of Trinidad and Tobago Limited CV 2012-02501, January 17, 2013, Rule 13.3, Judgment in default of defense, setting aside, delay. 2012 Privy Council/Court of Appeal. Rookman Balgobin v. Southwest Regional Health Authority, 2012, UKPC 11, May 10, 2012, Appeal allowed Part 13, Default Judgment, Procedural Bar against other defendants. Judy Bob v. Leslie Amity and others Civ App No. T254 of 2012, December 10, 2012, Appeal dismissed CV 2011-03617, November 22, 2012, Rule 13.3, Judgment, Default of Appearance, Default of Defense, setting aside, requirements satisfied. Roopnareens Linen Closet and Interior Accents Limited v. John Horsham Civ App No. P118 of 2012, November 6, 2012, Appeal allowed CV 2011-03821, May 16, 2012, Rule 13.3, Default Judgment, setting aside, requirements not satisfied. Delora Buckrady v. Winston B. Naidu and another Civ App No. P218 of 2012, October 29, 2012, Appeal allowed CV 2011-00962, September 27, 2012, Rule 13.3, Default Judgment, setting aside, requirements satisfied. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-101. Candy Sampson and another v. Kurt Semper Civ App No. S037 of 2012, May 3, 2012, Appeal dismissed CV 2010-4557, February 17, 2012, Rule 13.3, Default Judgment, setting aside, no realistic prospect of success. Southern Sales and Service Company Limited v. Lydia S. Bikram Civ App No. S020 of 2012, February 13, 2012, Appeal allowed CV 2009-04568, January 18, 2012, Rule 13.3, Default Judgment, setting aside, irregular service. High Court. Trevor Benjamin v. Sumintra Ramsarup and another CV 2008-04004, June 29, 2012, Part 13, Default Judgment, setting aside, delay. Francis Vincent v. Merlene Vincent and another CV 2008-01217, May 24, 2012, Rule 13.3, Default Judgment, setting aside, delay. 2011 Privy Council/Court of Appeal. The Attorney General v. Karen Matthews, 2011, UKPC 38, October 20, 2011, Appeal allowed default judgment, setting aside, no implied sanctions, Part 13 requirements sufficient, Rule 26.7 requirements not applicable, also under Parts 10 and 26. 2016 Supreme Court of Judicature of Trinidad and Tobago. 102 Consolidated Civil Proceedings Rules 2016. The Attorney General v. Universal Projects Limited, 2011, UKPC 37, October 20, 2011, appeal dismissed default judgment, setting aside the applicability of Rule 13.3 or Rule 26.7 requirements, also under Part 26. Rohini Khan v. Neville Johnston Civ. App No. S056 of 2011, April 18, 2011, appeal dismissed CV 2009-02311, April 12, 2011, Rule 13.3, judgment in default of appearance, setting aside, requirements satisfied. Sean Singh v. the Attorney General of Trinidad and Tobago Civ. App No. 265 of 2010, January 26, 2011, appeal dismissed with cost CV 2009-2340, December 14, 2010, Part 13, judgment in default of defense application TO set aside not a method to bypass prior ruling. 2009 Privy Council/Court of Appeal. Joseph Alexander v. Rosalind Baptiste and others Civ. App No. T099 of 2009, May 18, 2009, appeal allowed CV 2008-04227, May 12, 2009, Part 13, judgment in default of defense, setting aside, requirements not satisfied, also under Part 1. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-103. 2008 High Court. Noli John v. Brenda Mahaber and others CV 2005-00866, January 30, 2008, Rule 13.3, judgment in default of appearance, setting aside, requirements satisfied, also under Part 1. 2007 High Court. General Earth Movers Limited v. Estate Management and Business Development Company CV 2006-04052, November 6, 2007, Rule 13.3, default judgment, setting aside, requirements satisfied, Rule 13.5, condition imposed. 2016 Supreme Court of Judicature of Trinidad and Tobago. 104 Consolidated Civil Proceedings Rules 2016. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-105. Part 14 Judgment on Admissions. Contents of this part making an admission Rule 14.1 admissions by a minor or patient Rule 14.2 admission by notice in writing. Application for judgment Rule 14.3 action on receipt of admission in whole or in part of money claim Rule 14.4 admission of claim for specified amount of money Rule 14.5 admission of part of claim for money only Rule 14.6 admission of liability to pay the whole of a claim for an unspecified amount of money Rule 14.7 requests for time to pay Rule 14.8 requests for time to pay. Procedure where time and rate agreed Rule 14.9 requests for time to pay. Procedure where time and rate not agreed Rule 14.10 right of reconsideration Rule 14.11 variation of order Rule 14.12. Making an admission 14.1. A party may admit the truth of the whole or any part of any other party's case. 2. He may do this by giving notice in writing, such as in a statement of case, before or after the issue of proceedings. 3. A defendant may admit the whole or part of a claim for money by entering an appearance containing the admission. 4. He may do this in accordance with the following rules. A. Rule 14.4, admission of whole claim for specified sum of money. B. Rule 14.5, admission of part of a claim for a specified sum of money. C. Rule 14.6, admission of liability to pay whole of claim for unspecified amount of money. or D. Rule 14.7, admission of liability to pay claim for an unspecified amount of money where defendant offers a sum in satisfaction of the claim. 2016 Supreme Court of Judicature of Trinidad and Tobago. 106 Consolidated Civil Proceedings Rules, 2016. 5. Upon the defendant paying to the claimant the specified sum claimed together with interest and the appropriate fixed costs, as shown on the claim form, the claim is stayed. Part 67 Appendix A, Table 1 sets out the fixed costs. Admissions by a minor or patient. 14.2 The right to enter judgment on an admission is subject to Rule 23.12. Rule 23.12 provides that where money is claimed by or on behalf of a minor or patient, no settlement, compromise or payment shall be valid, so far as it relates to that person's claim, without the approval of the court. Admission by notice in writing application for judgment. 14.3.1, where a party makes an admission under Rule 14.1. 2. Admission by notice in writing, any other party may apply for judgment on the admission. 2. The terms of the judgment shall be such as it appears to the court that the applicant is entitled to on the admission. 3. An application to determine the terms of the judgment must be supported by evidence. Action on receipt of admission in whole or in part of money claim. 14.4 On receipt of an admission of the whole or part of a claim for money under Rule 14.1. 3. The court office must serve a copy of such admission on the claimant. Admission of claim for specified amount of money. 14.5. 1. This rule applies where a. The only remedy which the claimant is seeking is payment of a specified amount of money, b. The defendant admits the whole of the claim in his appearance or in his defense, and c. The defendant has not requested time to pay. 2. The claimant may file a request for judgment for the amount claimed, interest and for fixed costs, and may specify a. The date on which the judgment debt is to be paid, or b. The time and rate at which it is to be paid if by installments. 3. The court office must enter judgment in accordance with the request. Rule 12.6.3 sets out the circumstances under which a claim for the cost of repairing property damaged in a road accident can be treated as a claim for a specified sum. Part 67 deals with the quantification of costs. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-107. Admission of part of claim for money only. 14.6.1. This rule applies where a. The only remedy which the claimant is seeking is payment of money, and b. The defendant admits a specified amount of money in his appearance or in his defense. 2. The court office must serve a notice on the claimant requiring him to file a notice stating whether a. He accepts the amount admitted in satisfaction of his claim, or b. He wishes the proceedings to continue. 3. The claimant must a. File the notice, and b. Serve a copy on the defendant, within 14 days after the court's notice is served on him. 4. If the claimant does not file the notice within 14 days after the court's notice is served on him, a. The claim is stayed, and b. Any party may apply for the stay to be lifted. 5. If the defendant has not requested time to pay under Rule 14.8, the claimant may file a request for judgment for the amount admitted, interest and fixed costs, and may specify a. The date on which the judgment debt is to be paid, or b. The time and rate at which it is to be paid by installments. 6. The court office must enter judgment in accordance with the request. 7. If the claimant files notice under paragraph 2 that he wishes the claim to continue, the court office must fix a date, time and place for a case management conference. Part 27 sets out the procedure relating to a case management conference. Part 67 deals with quantification of costs. Admission of liability to pay the whole of a claim for an unspecified amount of money. 14.7.1. This rule applies where a. The only remedy the claimant seeks is the payment of money, b. The amount of the claim is not specified, c. The defendant admits liability in his appearance to pay the whole of the claim and does not, I. offer to pay a specified amount of money in satisfaction of the claim, or 2016 Supreme Court of Judicature of Trinidad and Tobago. 108 Consolidated Civil Proceedings Rules 2016. 2. File a defense stating that he will dispute the amount of the claim, and d. the defendant has not requested time to pay under Rule 14.8. 2. The claimant may file a request for judgment. 3. The court office must enter judgment in accordance with the request for an amount to be decided by the court and fixed costs. Part 16 deals with how the court decides the amount of the judgment. Part 67 deals with the quantification of costs. Requests for time to pay 14.8. 1. A defendant who makes an admission under Rule 14.5, 14.6, or 14.7 may make a request for time to pay. 2. A request for time to pay is a proposal about the date of payment or a proposal to pay by installments at the rates specified in the request. 3. The defendant's request for time to pay must be filed with his admission. 4. The defendant's request for time to pay must be accompanied by a statement of his financial position. 5. The statement must be certified by the defendant as being correct and may be used as evidence of the defendant's financial position at the date it was signed in any subsequent proceedings with regard to enforcement of the judgment. Requests for time to pay. Procedure where time and rate agreed 14.9.1. This rule applies where a. The only remedy which the claimant seeks is the payment of a sum of money in costs. b. The defendant, I, admits the whole of that claim or a specified sum, and 2. Requests time to pay or makes an offer to pay by installments, and c. The claimant states in his request for judgment on the admission that he accepts the defendant's offer as to the amount, time, and rate of payment. 2. Where this rule applies, judgment on the admission shall be judgment for the specified sum of money admitted, less any payments made, and fixed costs at the agreed time and rate. Part 67 deals with the quantification of costs. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-109. Requests for time to pay. Procedure where time and rate not agreed 14.10. 1. This rule applies where the claimant claims a specified sum of money and the defendant, A, admits the whole of that claim or a specified amount of money, and B, requests time to pay or makes an offer to pay by installments, and the claimant indicates in his request for judgment on the admission that he does not accept the defendant's offer as to the time and rate of payment. 2. Where this rule applies, the claimant must state in his request for judgment his reasons for objecting to the defendant's proposals as to payment. 3. If the claimant objects to payment by installments, the court must consider the defendant's request and the claimant's objections and enter judgment for the amount of the claim, interest and fixed costs on such terms as it sees fit. 4. The general rule is that the court should enter judgment under paragraph 3 without a hearing. 5. If the court decides to deal with the matter at a hearing, it must give the parties at least 7 days' notice of the hearing. Part 67 deals with quantification of costs. Right of reconsideration 14.111, where the court has determined the time and rate of payment under Rule 14.10 without a hearing, either party may apply for the decision to be reconsidered by the court at a hearing. 2. An application for reconsideration must be made within 14 days after service of the judgment on the applicant. Part 11 deals with applications. 3. At the hearing the court may confirm the judgment or make such other order as to the time and rate of payments as it considers just. Variation of Order 14.12. 1. Either party may apply to vary an order made under this part. 2. An application by a defendant must be in accordance with Part 48. 2016 Supreme Court of Judicature of Trinidad and Tobago. 110 Consolidated Civil Proceedings Rules 2016. Cases. 2016 High Court. Roberto Charles and another v. Shastri Prabhudial CV 2015-02739, March 2, 2016. Part 14, Judgment on Admissions, Clear Acceptance of Material Facts. 2012 Privy Council/Court of Appeal. David Walcott v. Graham Sweet and another Civ App No P070 of 2012, April 16, 2012. Appeal dismissed CV 2011-01769, April 13, 2012. Rule 14.1, Judgment on Admissions, NO Admission, CPR requirements not satisfied. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-111. Part 15 Summary Judgment. Contents of this part. Scope of this part. Rule 15.1 Grounds for Summary Judgment. Rule 15.2 Types of Proceedings for which summary judgment is available. Rule 15.3 Procedure. Rule 15.4 Evidence for the purpose of a summary judgment hearing. Rule 15.5 Powers of the Court on an application for summary judgment. Rule 15.6 Scope of this part. 15.1 This part sets out a procedure by which the court may decide a claim or part of a claim without a trial. Grounds for summary judgment. 15.2 The court may give summary judgment on the whole or part of a claim or on a particular issue if it considers that a. On an application by the claimant, the defendant has no realistic prospect of success on his defense to the claim, part of claim or issue, or b. On an application by the defendant, the claimant has no realistic prospect of success on the claim, part of claim or issue. Types of proceedings for which summary judgment is available. 15.3 The court may give summary judgment in any type of proceedings except a. Proceedings for redress under Section 14(1) of the Constitution, b. Proceedings for I. Judicial review, 2. False imprisonment, 3. Malicious prosecution, and 4. Defamation, c. Claims against the state, d. Admiralty proceedings in rem, and e. Probate proceedings. 2016 Supreme Court of Judicature of Trinidad and Tobago. 112 Consolidated Civil Proceedings Rules 2016. Procedure 15.4 1. Notice of an application for summary judgment must be served not less than 14 days before the date fixed for hearing the application. 2. The court may exercise its powers without such notice at any case management conference. Part 11 contains general rules about applications. Evidence for the purpose of a summary judgment hearing. 15.5 1. The applicant must a. File evidence in support with his application, and b. Serve copies on the party against whom he seeks summary judgment. 2. If the respondent wishes to rely on evidence, he must a. File the evidence, and b. Serve copies on the applicant and any other respondent to the application, at least 7 days before the summary judgment hearing. Powers of the court on an application for summary judgment. 15.6 1. The court may give summary judgment on any issue of fact or law whether or not such judgment will bring the proceedings to an end. 2. Where the proceedings are not brought to an end, the court must also treat the hearing as a case management conference. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-113. Cases. 2016 Privy Council/Court of Appeal. Adrian D. Ake v. Rachel Cyrus Civ App No. 169 of 2016, July 18, 2016. Appeal dismissed CV 2015-02452, June 7, 2016. Summary judgment, realistic prospect of success, substantive issues to be determined at trial, also under Part 26. Rainbow Court Townhouses Limited v. Sherlin Singh, Civ App P004 of 2016, May 9, 2016. Appeal dismissed summary judgment, breach of covenant, unsubstantiated defense, realistic prospect of success. High Court. Kamal Mohammed v. de Lamar Limited CV 2014-03593, June 3, 2016, Rule 15.3. Summary judgment entered, duty to answer material averments in statement of case, bear denial, reasonable prospect of success. 2015 Privy Council/Court of Appeal. Copyright Music Organization of Trinidad and Tobago v. Columbus Communications Trinidad Limited Trading as Flow Civ App number 167 of 2011, December 11, 2015, appeal allowed CV 2009-04722, June 14, 2011. 2016 Supreme Court of Judicature of Trinidad and Tobago. 114 Consolidated Civil Proceedings Rules 2016. Rule 15.2, Rule 15.6, Summary Judgment, Admission of Allegations, Sufficiency of Defense, Realistic Prospect of Success, also under Part 10. APUA Funding Limited and another v. RBTT Trust Limited Civ App number 94 of 2010, November 6, 2015, appeal dismissed Rule 15.2, Performance Bond, Illegality, Sufficiency of defense, Fraud, Realistic Prospect of Success. Sombat Mekawang v. Hilton International Trinidad Limited Civ App No P108 of 2015, July 6, 2015, appeal allowed Rule 15.2, A, Rule 15.3, Summary Judgment Issues of Fact to be determined at trial, also under Parts 26 and 31. Mervyn Assam v. Clico Investment Bank Limited and others Civ App number 49 of 2011, June 15, 2015, appeal dismissed CV 2009-04584, January 31, 2011, Rule 15.2, B, Summary Judgment, Establishing Cause of Action, Realistic Prospect of Success. Irene Noriega and others v. Ross McLean Civ App No P259 of 2015, March 14, 2015, appeal allowed Rule 15.2, B, Summary Judgment, Indefeasibility of Title, Fraud, Sufficiency of Claim, Grounds for Fuller Investigation. High Court. Kirk Ryan and another v. Karen Alexis CV 2014-04725, September 21, 2015, Rule 15.2, A, Summary Judgment, Possession, Locus Standi, Fraud, Bare Assertions, Realistic Prospect of Success. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-115. Mercury Marketing Limited v. VB Enterprises Limited CV 2014-02694, March 20, 2015, Rule 15.2, Summary Judgment, Sufficiency of Defense, Full Trial, Proportionality, Realistic Prospect of Success. Parks International Limited v. Juliana Webster CV 2010-01619, March 19, 2015, Rule 15.2, A, Reasonable Grounds for Defending Claim, Conflict of Facts, Realistic Prospect of Success. Clyde Moses v. Ronald Charles and another CV 2011-02341, March 9, 2015, Rule 15.2, Consideration of Principles, Arguability of Defense, Issue to be determined at trial, Realistic Prospect of Success. Lyris Blanchfield v. Nicola Blanchfield CV 2013-04792, CV 2014-00745, February 19, 2015, Summary Judgment, Consideration of Principles, Sufficiency of Defense, Bare Denial, Realistic Prospect of Success, also under Parts 10 and 38. 2014 Privy Council/Court of Appeal. Giselle Marfleet and others v. the University of Trinidad and Tobago Civ App No P104 of 2014, June 9, 2014, appeal dismissed CV 2013-00212, April 11, 2014, Rule 15.2, B, Summary Judgment, Arguable Claim, Appropriateness of Further Investigation, Realistic Prospect of Success, also under Parts 1. Millennium Park Limited v. Fareed Mohammed Civ App No. S249 of 2013, January 27, 2014, appeal dismissed CV 2012-3567, October 30, 2013. 2016 Supreme Court of Judicature of Trinidad and Tobago. 116 Consolidated Civil Proceedings Rules 2016. Rule 15.2, Sufficiency of Defense, Consideration of Evidence, Realistic Prospect of Success, also under Part 26. High Court. Yvonne R. Marichaux v. Maureen Barrett Pereira and another CV 2013-01568, September 29, 2014, Summary Judgment, Grounds for Defending Claim, Appropriateness of Further Investigation, also under Part 26. Angela Atong v. Diane Hunt CV 2013-00505, February 27, 2014, Rule 15.2, A. Summary Judgment, Payment of Commission, Realistic Prospect of Success, Appropriateness of Further Investigation, also under Part 26. Eunice Mayhew v. Ashram Persid and others CV 2013-01963, February 17, 2014, Rule 15.2, Summary Judgment, Piercing Corporate Veil, Determination of Important Issues, Requirement for Evidence. 2013 Privy Council/Court of Appeal. The Tobago House of Assembly v. Mentor Melville and others Civ App No. 254 of 2013 appeal pending CV 2011-04125, October 9, 2013, Rule 15.2, Summary Judgment, Consideration of Principles, Sufficiency of Defense, Realistic Prospect of Success. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-117. High Court. Wayne Yip Choi v. Angus Jura Holdings Limited CV 2011-03884, September 20, 2013, Part 15.2, Summary Judgment, Realistic Prospect of Success, Consideration of Principles. 2012 Privy Council/Court of Appeal. Maritime General Insurance Company Limited v. International Oil Pollution Compensation Fund Civ App No. 56 of 2008, July 23, 2012, appeal allowed setting aside, summary judgment, enforcement of foreign judgments, public policy. High Court. Bernard Hozam and another v. Damien Hozam CV 2011-04355, June 29, 2012, Rule 15.2, A. Summary Judgment, Time of Application, Defense not filed, Requirement for Oral Testimony. Zainim R. M. John v. Courtney Alsop and others CV 2010-04559, June 15, 2012, Rule 15.2, A. Summary Judgment, Indefeasibility of Title, Sufficiency of Defense of Fraud, Arguability of Adverse Possession, Realistic Prospect of Success. 2016 Supreme Court of Judicature of Trinidad and Tobago. 118 Consolidated Civil Proceedings Rules 2016. Supreme Court of Judicature of Trinidad and Tobago 2016. Consolidated Civil Proceedings Rules 2016-119. Part 16 Assessment of Damages. Contents of this part. Scope of this part. Rule 16.1 Assessment of Damages after default judgment. Rule 16.2 Assessment of Damages after admission of liability on claim for an unspecified sum of money. Rule 16.3 Assessment of Damages after direction for trial of issue of quantum. Rule 16.4. Scope of this part. 16.1 This part deals with the way in which the court decides the amount of any damages under a judgment for damages to be assessed. Assessment of damages after default judgment. 16.2 1. On applying for a default judgment to be entered under Rule 12.7 1 C, the claimant must state in writing, a. whether he is in a position to prove the amount of the damages, and, if so, b. his estimate of the time required to deal with the assessment, or c. if he is not yet in a position to prove the amount of the damages, the period of time that will elapse before he is able to do so. 2. Unless the claimant states that he is not in a position to prove the amount of damages, the court office shall a. fix a date for the assessment of damages, and b. give the parties at least 28 days notice of the date, time and place fixed for the hearing. 3. If the claimant is not in a position to prove the amount of damages, the court office shall a. fix a period within which the assessment of damages will take place, b. fix a date by which a listing questionnaire shall be sent to the claimant, and c. give the parties at least 28 days notice of the date, time and place fixed for the hearing. Rules 27.10 and 27.11 deal with the fixing of a date for trial. 4. Where a defendant against whom a default judgment is entered wishes to be heard on the issue of quantum and he has not so indicated under Rule 10.2, 2, he shall within 14 days of receipt of notice under Rule 16.2, 2, or 3, file and serve a notice in Form 7A indicating whether he wishes to. LN 126 of 2011. LN 126 of 2011. LN 126 of 2011. 2016 Supreme Court of Judicature of Trinidad and Tobago. 120 Consolidated Civil Proceedings Rules 2016. A. Cross-examine any witness called on behalf of the claimant. B. Make submissions to the court, or c. Call any evidence, in which case he shall file with the notice a statement of facts upon which he intends to rely. Assessment of damages after admission of liability on claim for an unspecified sum of money. 16.3, 1. On applying for judgment to be entered for damages to be assessed on an admission under Part 14, the claimant must state in writing, a. whether he is in a position to prove the amount of the damages, and, if so, b. his estimate of the time required to deal with the assessment, or c. if he is not yet in a position to prove the amount of the damages, the period of time that would elapse before he is able to do so. 2. Unless the claimant states that he is not in a position to prove the amount of damages, the court office shall a. fix a date for the assessment of damages, and b. give the parties at least 28 days notice of the date, time and place fixed for the hearing. 3. If the claimant is not in a position to prove the amount of damages, the court office shall a. fix a period within which the assessment of damages will take place. b. Fix a date by which a listing questionnaire shall be sent to the claimant, and c. give the parties at least 28 days notice of the date, time and place fixed for the hearing. Rules 27.10 and 27.11 deal with the fixing of a date for trial. 4. The defendant is entitled to cross-examine any witness called on behalf of the claimant and make submissions to the court, but is not entitled to call any evidence unless he has filed a defense setting out the facts he seeks to prove. Assessment of damages after direction for trial of issue of quantum. 16.4, 1. This rule applies where the court makes a direction as to the trial of an issue of quantum. 2. The direction may be given at a. a case management conference, b. the hearing of an application for summary judgment, or c. the trial of the claim or of an issue, including the issue of liability. LN 126 of 2011. LN 126 of 2011. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-121. 3. On making such a direction, the court must exercise the powers of a case management conference and must in particular give directions about a. disclosure, b. service of witness statements, and c. service of expert reports. 4. The court must also a. fix a date on which the court office is to send a listing questionnaire to the parties, and b. fix a period within which the assessment of damages must commence. Rules 27.10 and 27.11 deal with the fixing of a date for trial. Former Rule 1. The current Rule 16.2 was brought about by the deletion and substitution of subrules 2 and 3, and the insertion of subrule 4 by Rule 8 of the Civil Proceedings Amendment Rules, 2011 Legal Notice Number 126 of 2011. As set out in the 2006 publication, subrules 2 and 3 read as follows. 2. Unless the claimant states that he is not in a position to prove the amount of damages, the court office must fix a date for the assessment of damages and give the claimant at least 14 days notice of the date, time and place fixed for the hearing. 3. If the claimant is not in a position to prove damages, the court office must fix a period within which the assessment of damages will take place and a date on which a listing questionnaire shall be sent to the claimant. Rules 27.10 and 27.11 deal with the fixing of a date for a trial. 2. The current Rule 16.3 was brought about by the deletion and substitution of subrules 2 and 3 by Rule 9 of the Civil Proceedings Amendment Rules, 2011 Legal Notice Number 126 of 2011. As set out in the 2006 publication, subrules 2 and 3 read as follows. 2. Unless the claimant states that he is not in a position to prove the amount of damages, the court office must fix a date for the assessment of damages and give the claimant at least 14 days notice of the date, time and place fixed for the hearing. 3. If the claimant is not in a position to prove damages, the court office shall fix a period within which the assessment of damages will take place and a date on which a listing questionnaire is to be sent to the parties. Rules 27.10 and 27.11 deal with the fixing of a date for a trial. 2016 Supreme Court of Judicature of Trinidad and Tobago. 122 Consolidated Civil Proceedings Rules 2016. Cases. 2011 Privy Council/Court of Appeal. Sunil Chankersing and another v. Crystal Morton Gittins Civ App S010 of 2011, June 1, 2011, appeal allowed in Part Rule 16.4, Assessment of Damages, Quantum of Damages, Separation of Issues of Liability and Quantum, also under Part 27. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-123. Part 17 Interim Remedies. Contents of this part: orders for interim remedies. Rule 17.1 time when an order for an interim remedy may be made. Rule 17.2 how to apply for an interim remedy. Rule 17.3 interim payments. General procedure. Rule 17.4 interim payments. Conditions to be satisfied and matters to be taken into account. Rule 17.5 powers of court where it has made an order for interim payment. Rule 17.6 power of court to order early trial, etc. Rule 17.7 Orders for interim remedies. 17.1 The court may grant interim remedies including a. An interim injunction, b. An interim declaration, c. An order, i. For the detention, custody or preservation of relevant property, 2. For the inspection of relevant property, 3. For the taking of a sample of relevant property, 4. For the carrying out of an experiment on or with relevant property, v. For the sale of relevant property, including land, which is of a perishable nature or which for any other good reason it is desirable to sell quickly, and 6. For the payment of income from a relevant property until a claim is decided, d. An order authorizing a person to enter any land or building in the possession of a party to the proceedings for the purposes of carrying out an order under subparagraph c. e. An order to deliver up goods, f. An order referred to as a freezing injunction. I. Restraining a party from removing from the jurisdiction assets located there, or 2. Restraining a party from dealing with any assets whether located within the jurisdiction or not. 2016 Supreme Court of Judicature of Trinidad and Tobago. 124 Consolidated Civil Proceedings Rules 2016. G. An order, referred to as a search order, requiring a party to admit another party to premises for the purpose of preserving evidence, etc. H. An order, referred to as an order for interim payment, under Rule 17.5 for payment by a defendant on account of any damages, debt, or other sum which the court may find the defendant liable to pay. I. An order for interim costs. J. An order for a specified fund to be paid into court or otherwise secured where there is a dispute over a party's right to the fund. K. An order permitting a party seeking to recover personal property to pay money into court pending the outcome of the proceedings and directing that, if he does so, the property shall be given up to him. L. An order directing a party to prepare and file accounts relating to the dispute. And M. An order directing a party to provide information about the location of relevant property or to provide information about assets which are or may be the subject of an application for a freezing injunction. 2. In paragraph 1c and m, relevant property means property which is the subject of a claim or as to which any question may arise on a claim. 3. The fact that a particular type of interim remedy is not listed in paragraph 1 does not affect any power that the court may have to grant that remedy. 4. The court may grant an interim remedy whether or not there has been a claim for a final remedy of that kind. Time when an order for an interim remedy may be made. 17.2. 1. An order for an interim remedy may be made at any time, including a. before a claim has been made, and b. after judgment has been given. 2. However, a. paragraph 1 is subject to any rule which provides otherwise. B. The court may grant an interim remedy before a claim has been made only if I. the matter is urgent, or 2. it is otherwise necessary to do so in the interests of justice, and c. unless the court otherwise orders, a defendant may not apply for any of the orders listed in Rule 17.1(1) before he has entered an appearance under Part 9. 3. Where the court grants an interim remedy before a claim has been commenced, it must require an undertaking to issue a claim. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-125. How to apply for an interim remedy. 17.3(1). The court may grant an interim remedy on an application made without notice if it appears to the court that there is good reason for not giving notice. 2. An application for an interim remedy must be supported by evidence. 3. If the applicant makes an application without giving notice, the evidence in support of the application must state the reason or reasons why notice was not given. 4. If no claim has been issued, the application must be made in accordance with the general rules about applications contained in Part 11. Interim payments, General Procedure 17.4(1). The claimant may not apply for an order for an interim payment before the end of the period for entering an appearance applicable to the defendant against whom the application is made. Rule 9.3 sets out the period for entering an appearance. 2. The claimant may make more than one application for an order for an interim payment even though an earlier application has been refused. 3. Notice of an application for an order must a. be served at least 14 days before the hearing of the application, and b. be supported by evidence. 4. The evidence must a. state the claimant's assessment of the amount of damages or other monetary judgment that is likely to be awarded, b. set out the grounds of the application, c. exhibit any documentary evidence relied on by the claimant in support of the application, and d. if the claim is made under the Compensation for Injuries Act, Chap. 805, in respect of injury resulting in death, contain full particulars of the person or persons for whom and on whose behalf the action is brought and the nature of the claim in respect of which the damages are sought to be recovered. 5. If the respondent to an application for an interim payment wishes to rely on evidence or the claimant wishes to rely on evidence in reply, that party must a. file the evidence, and b. Serve copies on every other party to the application, at least 7 days before the hearing of the application. 6. The court may order an interim payment to be made in one sum or by installments. 2016 Supreme Court of Judicature of Trinidad and Tobago. 126 Consolidated Civil Proceedings Rules 2016. Interim payments, conditions to be satisfied and matters to be taken into account. 17.5. 1. The court may make an order for an interim payment only if a. The defendant against whom the order is sought has admitted liability to pay damages or some other sum of money to the claimant. b. The claimant has obtained an order for an account to be taken as between himself and the defendant in judgment for any amount certified due on taking the account to be paid. c. The claimant has obtained judgment against that defendant for damages to be assessed or for a sum of money, including costs, to be assessed. d. Except where paragraph 3 applies, it is satisfied that, if the claim went to trial, the claimant would obtain judgment against the defendant from whom he is seeking an order for interim payment for a substantial amount of money or for costs, or e. The following conditions are satisfied. I. The claimant is seeking an order for possession of land, whether or not any other order is also being sought, and 2. The court is satisfied that, if the case went to trial, the defendant would be held liable, even if the claim for possession fails, to pay the claimant a sum of money for rent or for the defendant's use and occupation of the land while the claim for possession was pending. 2. In addition, in a claim for personal injuries, the court may make an order for the interim payment of damages only if the defendant a. is insured in respect of the claim, b. is a public authority, or c. is a person whose means and resources are such as to enable him to make the interim payment. 3. In a claim for damages for personal injuries where there are 2 or more defendants, the court may make an order for the interim payment of damages against any defendant if a. It is satisfied that, if the claim went to trial, the claimant would obtain judgment for substantial damages against at least one of the defendants, even if the court has not yet determined which of them is liable, and b. Paragraph 2 is satisfied in relation to each of the defendants. Consolidated Civil Proceedings Rules 2016-95. Former rule. The current Rule 12.11 was brought about by the revocation and substitution of Rule 12.11 by Rule 7 of the Civil Proceedings Amendment Rules, 2011.